So I would like to introduce our speakers for this fourth panel. We have Dustin Berger, who's an associate in our Denver office, and one of our security experts. Dustin has a CISSP certification, which if you're a security person, you know not many lawyers have. Jennifer Coates, who's a litigation partner and handles a lot of incident response. Deborah Howitt, who's a partner in our Denver office and handles a broad range of privacy and cybersecurity matters, and Jessica Liano, who's a litigator in our Southern California office, handling privacy-related litigation in California. I will turn it over to this panel. Thank you very much.
Hey, thank you so much, Jamie. So I'm Deb Howard in the Denver office, as Jamie mentioned. So thank you all for being here today. In this panel, we will give you an overview of some of the recent trends in privacy litigation, including some recent litigation under some newer theories involving some pretty old statutes we'll discuss. And then we will also cover data breach trends and cybersecurity measures designed to prevent data breaches. So first, I'd like to mention that in recent years, we've seen plaintiffs' attorneys bringing privacy litigation claims under some statutes that were first enacted long before the internet existed. Some of their arguments are pretty creative, I have to admit, but the proliferation of these cases has resulted in a tidal wave of litigation against companies who are not, in fact, violating any of the current privacy laws that were just discussed in our earlier panels, such as the CCPA or these other state laws. Instead, they are bringing up some very old statutes and interpreting some of the requirements of the statutes in new ways. Many of the claims faced by companies are now arising simply because they use the metapixel on their site, which is really broad common practice for just about any company engaged in any consumer-facing marketing these days. And it's been in use for almost 2 decades now. So it's certainly not something anybody would consider to be an outrageous practice or offensive or any of the types of claims that previously had to be proven under privacy tort litigation in the past. In case you're not aware, the metapixel is just a small piece of code that companies can place on their websites in order to receive insights into how the site's audience interacts with their ads on Meta's social media platforms, Facebook and Instagram, how those users behave on the company's own website after they click on an ad. It helps to track ad conversions and just optimizing advertising and marketing practices in very common and widespread ways across consumer-facing websites. So these latest cases are really just about the numbers. They're being filed under laws that have statutory damages per violation. And I think that's what the plaintiffs' attorneys are focused on. So they're filing as many suits as possible, even if there's really sort of no tangible harm to individuals. And even when it's not truly clear if the statute is applicable to the circumstances, just knowing that many of the defendants will settle and different courts have different interpretations and opinions on, what is relevant and what is actually covered under the law and what should be dismissed. So there's a lot going on in this area, but many of them are surviving motions to dismiss, and it's resulting in hundreds of cases being filed. One of these older laws for which litigation has recently increased is the Federal Video Privacy Protection Act, the VPPA. So this law was enacted back in 1988 following the Supreme Court confirmation hearings for Robert Bork, in which his video rental history was disclosed. So this law was designed for companies such as Blockbuster back in the day to prevent those companies from disclosing a customer's video rental history without prior express written consent. The VPPA was more recently amended to make it clear that it does apply in online video content delivery, but these cases are really stretching a lot of these definitions. So Jessica, I know you've been working on quite a few of these cases. Can you please provide an overview of what types of companies can be held liable under the VPPA?
Yes, happy to. Thank you, Deb. So to repeat what Deb said, the VPPA imposes liability on a videotape service provider who knowingly discloses to any person personally identifiable information concerning any consumer of such provider. And as Deb mentioned, plaintiffs are now seeking to expand the VPPA to new technology. And recent cases have turned on several elements of the statute, but usually one, the videotape service provider element and the consumer element. Now, as to the first, who is a videotape service provider or what company can be found a videotape service provider, the VPPA defines a videotape service provider as any person engaged in the business in or affecting interstate or foreign commerce of rental, sale, or delivery of pre-recorded video cassette tapes or similar audiovisual materials. And given that we are not frequently watching content on a pre-recorded video cassette tape, whether a company is engaged in the business of providing similar audiovisual materials is often the key. So, as Deb mentioned, when you hear the term videotape service provider, you might think of a Blockbuster or something like a Redbox where you're buying or renting a videotape or DVD. But we're seeing plaintiffs bring VPPA claims against a wide range of companies, whether they sell a food product, clothing, really running the gamut of products and companies, as long as the company is offering promotional video content on their websites. And this theory we're seeing most often alleged is that by using an analytics tool like the Metapixel, the company is violating the VPPA. Specifically, plaintiffs are alleging that when a user is logged into their Facebook account and they watch a video, even if it's a promotional video on a company's website, the Metapixel is transmitting information about the person watching the video and the video they watched to Facebook. And plaintiffs are arguing that this practice violates the VPPA's prohibition on disclosing consumers' video watching history. And so going next slide, please. So in looking at which type of companies can be liable under the VPPA and what it means to be a videotape service provider, courts are looking at what it means to be engaged in the business specifically. So to be engaged in the business of delivering video content, the defendant's product must not only be substantially involved in the conveyance of video content to consumers, but also significantly tailored to serve that purpose. And we're seeing the last phrase, which is the significantly tailored to serve that purpose phrase, be key in a lot of these cases. So in one case involving modern technology, which is Patreon, the website where you can subscribe or pay to access content creators' videos, podcasts, other media, the court denied Patreon's motion to dismiss. The court found that allegations that customers were paying Patreon to access content creators' videos was sufficient to allege that Patreon was engaged in the business of delivering video content. And the court found that to be the case, even if Patreon wasn't the one making the content. On the other hand, courts have also held that using videos for marketing or increasing brand awareness is not enough to be engaged in the business of providing video content. So I provide here a few examples of recent cases where courts found that the defendant was not engaged in the business and could not be liable under the VPPA. So in one of these cases, Hernandez versus Justin's Inc., this was actually a case litigated by one of my colleagues and I, the court held that it was not plausible to allege that defendant was engaged in the business of delivering video content simply by including pre-recorded videos on its website that market the products that defendant does sell. And for Justin's, that would be selling school memorabilia or class rings. That was far different, the court found, than a company like Patreon, who makes money or their business models based off selling video content. The court found the same thing in Cantu versus Tapestry Inc., which was a case against Tapestry, which is the brand Coach. So advertising via videos, its purses, scarves, other accessories was not enough to make Coach a videotape service provider under the VPPA. And the court found the same thing in a case against Chick-fil-A, rejecting the allegations that Chick-fil-A having some video content on its websites to promote its food was enough to bring it within the scope of the VPPA. So Deb, we're seeing courts really focus on, one, what is the business doing? What is the company's focus? Is their business model focused on selling video content? Or is the video content really incidental to the goods or services that they really do sell and focus on selling?
Thank you so much, Jessica. That's very helpful regarding the companies who can be sued under this statute. But what about the potential claimants, the consumers who have viewed the videos? Are they also looking to expand the definition of who could bring a claim under the VPPA in these cases?
Yes, Deb. So plaintiffs are certainly trying to expand the definition, and courts have helpfully been narrowing the definition for some of the companies. If you don't mind moving to the next slide, Jamie. The VPPA provides another helpful definition, which is the definition of a consumer. So the VPPA defines a consumer as any renter, purchaser, or subscriber of goods or services from a videotape service provider. And courts have clarified that the plaintiff must be a consumer or subscriber of the defendant's video content. And buying something from the defendant other than video content is not enough. So the VPPA provides for an action by a renter, purchaser, or subscriber of audiovisual materials. And courts have taken that to mean this is literally purchasing audiovisual materials. It's not meant to apply to a broader category of consumers who may buy some product that has nothing to do with videos or anything else audiovisual. And we saw the court make this conclusion in ruling on a motion to dismiss in a recent case against the Container Store, which is in the Central District of California. So just a few months ago, the district court granted a motion to dismiss brought by the Container Store. And in this case, the plaintiff brought a fairly creative theory, arguing that they had gone to the Container Store, bought some type of container product, and therefore they were a consumer for purposes of a VPPA claim because they bought something from the defendant. And the court provided some clarification that this is not what the statute was intended to regulate. So even in cases where the court has found the defendant may be a videotape service provider, VPPA claims have still been dismissed for failure to allege a consumer or subscriber element. If you can go to the next slide, please, Jamie. So because these cases are often turning on promotional video content, as we've discussed, embedded videos advertising a product or showcasing the defendant's goods or services, we don't usually have plaintiffs arguing a typical consumer relationship in the sense that it's a consumer paying for something, they get something back. So the statute does mention that a consumer can also be a subscriber. But even in the day of new technology and access to lots of video content, courts have still put some parameters on what it means to be a subscriber under the VPPA. And courts have held in several cases that subscribing to a free newsletter is not enough. And this is the type of newsletter we often see once you make a purchase from a website. You'll start getting emails about, buy this product, here's a sale. So we've seen cases, including this first case, Carter versus Scripps, where plaintiffs have alleged that they subscribed to a free newsletter from the defendant, and because they subscribed to that newsletter, they are now a subscriber for purposes of the VPPA. So in this first case, Carter, plaintiffs watched free video content from HGTV on hgtv.com, and then brought VPPA claims against HGTV, arguing that they were a subscriber because they signed up for a promotional newsletter from HGTV. And here the court provided a helpful definition of what subscriber means for the VPPA. Free newsletters may entice or encourage recipients to view the defendant's videos, but plaintiffs didn't assert that a newsletter was required to access those videos, was required to log in and view the videos, or gave the subscribers any extra benefits as viewers. This is in contrast to a case like Patreon, where paying and making a login get you access to video content that someone who doesn't have a login or doesn't have a subscription relationship, they don't have those same benefits. And we've also seen some clever theories where plaintiffs are alleging that they've downloaded the defendant's app. So this could be an app that you use in the store to scan products or to look at what's being sold, whatever is promotional. And courts have held that downloading a free app is not necessarily enough either to be a subscriber. In one case, against Cartoon Network, which did involve some video content, the court still held that there was no subscription relationship, and there was thus no VPPA claim. The court in Cartoon Network held that a person who downloads and uses a free mobile application on their smartphone to view freely available content without more is not a subscriber. Now, this is an example of where the courts are applying factors to determine whether someone is a subscriber. Payment can be a factor, but it's not required. And courts are also looking at things like the level of commitment. Are you required to make a login? And in order to view content on the app, you have to log in. Or is it simply one can open the app and they view free videos? So in contrast, in another case against a media provider, Gannett, the plaintiff did allege sufficiently that he was a subscriber of the defendant's video content for VPPA purposes, even though the content was free, because the content on the app could only be accessed after the user provided personal information to defendant, such as their Android ID and their GPS location. So there are several factors that will turn on the subscriber or consumer relationship, but Deb, we're seeing courts still put some parameters on who can be a plaintiff and who is a defendant for a VPPA claim.
Okay, great. Thank you so much. Another even older statute we've seen being resurrected for litigation recently is the Federal Wiretap Act and some analogous claims under similar state wiretap laws. So Jennifer, can you please give us a brief overview of those statutes and what they were designed to achieve originally? And can we move to the next slide, please? Jennifer, we can't hear you. Still can't hear you. Still can't hear you. Jessica, do you want to jump in?
Can you hear me now?
Oh, yes, we can hear you now. Okay, thanks.
Sure. So the federal wiretap statutes were designed in 1986 in order basically to avoid people intercepting information from rotary dial phones. Now, I don't know about you, but if you look in my house and you show my children a rotary phone, they actually don't even know what it is. And so when you think about how old the technology is that it was originally designed to address, it's hard to imagine how it's also now being used with privacy litigation. As a trial lawyer and as a litigator, I can tell you that, you know, if you look throughout U.S., the United States' case law, its history, U.S. is often trying to relate back to one of its principles so that it's not necessarily recreating the wheel every single time. And the reason for that really has to do with government just in law is just not going to move as fast as technology and as fast as private industry. And so when you see the government or relating back, courts relating back to wiretap or VPPA or even plaintiffs' attorneys, what they're doing is they're trying to not make the court recreate the wheel. Now, plaintiffs' attorneys are incredibly smart. I don't know that people always give them credit for being as smart as they are. And one of the things that they're very good at is understanding that history, that jurisprudence, and how the United States court system relates back to its earlier, I guess, for lack of better world foundation and form. So when you're looking at the Wiretap Act, which is essentially designed to not intercept somebody else's communication, and it has to be done with intent. Intent is defined very specifically as it can't just be an accident. The company doing it actually has to intend for something like this to occur. The communication itself is defined, as well as content is defined as, you know, the real substance of what is intended to be communicated. So there are fairly specific definitions here that are actually going to help courts, I guess, put some parameters around these types of lawsuits. What you're essentially seeing with wiretap are really two separate types of theories on the case. One is essentially chatbots. So chatbots, for those of you who don't know, if you're on a website late at night, you might see somebody say to you, hey, can I help you? Can I help you? And it'll just sort of flash for you. And you think to yourself, who possibly could be up at 2 o'clock in the morning and willing to answer all of my questions? Well, the answer is nobody is up at 2 o'clock in the morning, willing to answer your questions. What's really happening is you are engaging with the chatbot. And essentially, the theory of the case is that the chatbot is encouraging people to provide information about themselves, private information that's protected, or information that talks about how, in fact, they engage with the website. And that is considered to be information that should be protected, at least according to plaintiffs' counsel and plaintiffs' attorneys. Thus far, it has not been completely successful, but it has been somewhat successful in that it depends on the kind of information that the individual is supposedly providing to the chat bot. One industry that's having a really difficult time right now is the healthcare industry. And that leads into both chatbot information as well as session replay information. In fact, there was just a case filed yesterday, about 18 hours ago, it was reported down here or down in North Carolina. And so when you're thinking about chatbots and those other types of platform operators, a couple of things. One, is it being run in-house? Almost never is it being run in-house. It's almost obviously a contracted out third-party vendor. So then the question is that third-party vendor a part of the conversation? And if that third-party vendor is a part of the conversation, what type of information are they being given, and what type of information are they collecting? More significantly, what information have they been instructed to collect? Essentially, what that will come down to, and what that will instruct courts and litigation strategy regarding, is how much is this, how liable is that third party versus the liability of the main or the person that has contracted for this service. The other place that we're seeing a lot of wiretap litigation is in session replays. So session replays, and this is also something that healthcare industries and hospitals are having some difficulty with, but session replays essentially gives somebody an opportunity to say, this is how this person came into the website and this is where they went. So I know years and years and years ago, there was a Target story about a man who called Target very upset and angry because Target had sent his teenage daughter some coupons for prenatal stuff. And he called Target and said, my daughter's 15 or 16, however old she was, and she's not pregnant. How dare you send her these coupons for baby stuff? Well, it turned out his daughter was in fact pregnant. And Target had figured that out based on tracking how she went through the store and how she had picked up products, what she had picked up, and how she had purchased them. And it was tracking that type of data. So if you think about, on the other side, now somebody on a website, for instance, in a hospital or a medical facility, and thinking about, okay, I'm going to go check for colon cancer today, or I'm going to go check for breast cancer or whatnot, and that information being collected and the person going through, the website, that being collected, and then somebody coming back and having either selling that information and that data. So now you're getting, medical advertisements, whatever it is. That has been a huge basis for litigation at this point. And so I think that, as always, these tools were created for the purpose of bringing probably a better customer experience, but they obviously have some monetary value. Under the wiretapping statute, essentially what it's saying is, and it's contemporaneous as opposed to asynchronous, but as you are contemporaneously collecting this information, you are intercepting my information for a purpose that is essentially commercial, and that's not permitted. That's the theory of the case. It may seem like a stretch, but it is surviving motions to dismiss, mostly in California and Florida, but also in other states around the country.
Okay, thank you. Jessica, I know you've litigated some of these cases also. What are some of the defenses that you've seen be successful pretty commonly in these wiretapping cases?
A few different defenses we're seeing, Deb. One we see less commonly the basis for a motion to dismiss, but one nonetheless is whether the pixels or whatever technology is being used is obtaining or transmitting contents of an electronic communication. So as Jennifer mentioned, content is really the communication itself, what is being said. That is covered by the wiretapping laws, both California and federal. But what's not covered is record information. So record information, some courts have held, includes, among other things, a name, an address, or a subscriber number or identity. So in cases where plaintiffs haven't alleged that there's a transmission or interception of contents of a communication, we've seen some courts determine that there may not be a wiretapping claim there. Another big issue we see come up is the issue of consent. So consent is a defense to privacy claims. This includes wiretapping claims, common law claims like invasion of privacy, intrusion upon seclusion. If you've consented to the conduct you're not complaining of, you have no claim, you've consented. So we see some different claims brought here. One thing to note is that the Federal Wiretap Act only requires one-party consent. So if in a chatbot claim, for example, the company that has a chatbot on its website knows that a vendor is involved and may be getting copies of a communication, that's enough consent to defeat a privacy claim. On the other hand, California, for example, requires all parties' consent to the communication. Let's go to the next slide, please. So here, when it comes to website litigation and privacy claims, we see privacy policies in terms of use or terms of service come into play. And we've seen courts dismiss claims where the defendant can establish that the plaintiff assented to their data being shared with a third party. In other words, if the defendant told the claimant or put them on sufficient notice of the activity, including, sharing data, the plaintiff could be deemed to have consented. So some examples of courts that have dismissed privacy claims include the Northern District of California in the Inri Yahoo Mail litigation case. And in this case, the court found that there was consent to the activity complained of and granted the motion to dismiss. In short, the plaintiffs were Yahoo email users who claimed that Yahoo was scanning their emails from non-Yahoo accounts and scanning for information before the emails were delivered to the Yahoo email user. However, the Yahoo pointed to evidence that to make a Yahoo email account, the user had to click a button that said create account, and under the button, there was language that said, I agree to the Yahoo terms of service and Yahoo's privacy policy with the hyperlink to both. And if you clicked on the hyperlink, the terms of service and the privacy policy said directly, we will scan your emails, and that's part of our service. By using our service, by using our email function, you consent to that. So in other words, the court found that Yahoo had disclosed what it was going to do, and that conduct was alleged as the basis for the wiretapping claims. Therefore, there was consent because plaintiffs agreed to let Yahoo do what they did. A similar case was a case against Zimride, the rideshare service. In that case, plaintiffs similarly alleged that Zimride, through the app, was disclosing information about them to a third-party analytics service. And in that case, too, the court found that there was consent because at the time the plaintiff signed up for Zimride, downloaded the app, entered their information, they were presented with terms of service and a privacy policy that said, we may use the information you provide to the app. When you take a ride or you sign up to take a ride, we may provide that to a third party. And that was the basis of the plaintiff's claims. So in that case, the court also found consent. So a real takeaway from a lot of these wiretapping cases that turn on consent is, one, what language is in the privacy policy or the terms of service? For instance, if the claimant's claim is, we didn't know you were using cookies, does the privacy policy say, we use cookies? What exactly is being disclosed? How detailed is the information? And how is it presented to the consumer? Is there a cookie banner that pops up at the bottom of the page when you land on a website? with hyperlinks? Is it buried in a hyperlink at the bottom of a page that one might not see? Is it buried within other language about other aspects of the defendant's service? But to the extent you can present evidence that, the consumer had to consent, they had to click something, they were presented with terms, and the terms told them exactly what you were going to do, and that's what they, are bringing a claim based on. You may have consent, and consent is a complete defense to privacy claims.
Great, thank you so much. Now, more recently, we have seen numerous cases regarding pen register and trap and trace claims. Can you give us an overview of those, Jessica, and what are some of the issues there?
Sure, next slide, please, Jamie. Sure, so one claim we're seeing recently, as the chatbot, as Jennifer mentioned, we're seeing that be the basis for federal Wiretap Act claims and also California invasion of privacy, or CIPA claims. So in addition to chatbot claims, what we're seeing very frequently now are pen register or trap and trace claims. So under a different provision of CIPA, different from the wiretap provision, the California legislator holds that a person may not install or use a pen register or trap and trace device without first obtaining a court order. And when you think of a pen register or a trap and trace device, you may be thinking law enforcement. These are tools that were used to effectively generate a call log and see incoming and outbound calls. But following a 2023 decision in Greenlee versus Kuchava, plaintiffs are now bringing an onslaught of pen register or trap and trace claims based on the same analytics technology. So in this case, Greenlee, the plaintiffs allege that the defendant was selling a software developer kit, and the software developer kit was collecting data from app users, and this was the equivalent of a pen register. The court rejected the defendant's arguments on a motion to dismiss that pen register under CIPA was really constrained to a physical machine connected to a phone line. This decision that broadened the definition of what could be a pen register under CIPA has led to a wave of new claims, many of them filed at the end of 2023 and beginning of 2024. So we're keeping an eye on these cases to see how courts rule on this issue, as well as specifically whether tracking technology on a website can be a pen register or trap and trace device within the meaning of the CIPA, or whether we'll see a number of these claims get dismissed based on legislative history and interpretation of what exactly the courts and Congress meant to limit with this statute.
Okay, great, thanks. Yeah, I would guess when those were enacted, no one was expecting to see these claims in 2024 related to the internet, but here we are, and as you mentioned, there's been a lot of them. So another state statute under which we've seen a significant amount of litigation is the Illinois Biometric Information Privacy Act, which we refer to as BIPA. So Jennifer, can you please give us an overview of BIPA and what we're talking about here with regard to biometric information?
Thank you, Deb. So the Illinois Biometric Information Privacy Act essentially prohibits private companies, entities from capturing or collecting biometric data and receiving it through trade and then using it for commercial purposes. They can't necessarily, well, let me back up a little bit. Whenever I think about BIPA, I think about like any James Bond type movie, whatever technology is happening in 50 years from now. And essentially what BIPA is trying to do, and it was really promoted and pushed by the Illinois ACLU, which is you have to tell people whether or not their thumbprint is, to getting into their phone, whether or not that's going to be captured, how long it's going to be captured, and exactly what it's going to be used for. The second step of that is, how is that information going to be protected? Because unlike a password, or to some extent, I would argue, a bank account number, those things can be changed. But your facial recognition, your iris scan, your fingerprint, those are things that cannot be changed. And so Illinois, which has, it's really the first of its kind in the United States, was enacted in the early 2000s. I mean, it was really way up in front of its time, ahead of its time. But the whole purpose of it is to make sure that consumers generally know, understand, and they have some guarantees about how their biometric information is going to be used. One of the difficulties with the BIPA information is, like face recognition software, there is a significant learning curve that has not yet been conquered regarding racial identification and to some extent gender identification. And so I give an example to people, they never quite believe it, but I have 2 children, a boy and a girl. They're 5 years apart, and they can use each other's faces to open each other's iPhones using Face ID. And it's likely because they look a lot alike. But like I said, they're significantly, difference in age, gender, etc. So if you think about that, and whether or not, that's particularly for my family of African descent. But, if facial recognition, in fact, is not differentiating between people based on, for instance, race, gender, etc., then we have the issue of, can people's identities be stolen, even though it's their information, it's their biometric information. Next slide. Okay. Courts have really been very hard on plaintiffs, so they dismissed BIPA claims if defendants cannot tell you how that information is being used for identification. So essentially, plaintiffs' attorneys, again, incredibly smart, are bringing all kinds of incredible claims. And I think I got that backwards. I'm sorry, I think I said that backwards. I said that the plaintiffs, but let me just read it. Courts have dismissed BIPA claims absent allegations that the defendant is using or is capable of using that information for identification. I said that backwards. I said plaintiffs. But in terms of courts dismissals, as a corporation, one of the things that you really want to be able to discuss is how that information is being used, or even if you are capable of using that information. At some point, plaintiffs' lawyers are going to get past this hurdle. Once they get past that hurdle, the question will be your policies, your procedures, and what is written down, and to some extent, your training.
So Jessica, I know you've worked on some BIPA cases recently that involved virtual try-on technology. Can you describe those a little bit for us?
Sure. So we are seeing a number of cases involving, as Deb mentioned, try-on technology. So this is the type of feature where you go on a website, you're interested in buying, a certain type of eyeglasses. And before buying them, you can take your picture or upload a picture, and the website will generate an image of you wearing these eyeglasses, or the same with hair extensions or makeup products. So we're seeing a lot of courts expand, or we're seeing a lot of plaintiffs try to expand the coverage of BIPA beyond the fingerprint or the facial scan to try-on technology. So we've given you some examples of cases where, defendants were brought into BIPA suits that are not the type of company you think is doing, as Jennifer mentioned, the James Bond type of technology. So one was a case against Avita, and this was just a December 2023 case. And this involved try-on technology. And the court dismissed the claim because, as Jennifer and Deb have mentioned, BIPA really turns on, are you doing any type of identification with the information? Even if a company is collecting what counts as biometric identification or biometric information, there's no BIPA claim unless the defendant is using that information for purposes of technology. So in the Avita case, the court held that plaintiffs didn't allege that Avita was taking the consumer's images and comparing it to a database of existing customers, or that they had any kind of database and were running the images collected against the database. And just a few months ago, another Illinois district court held the same in a case against Estee Lauder, involving another makeup feature. There, the court also held that there were no allegations that Estee Lauder was comparing people's images, even if, there was some kind of layering or putting on makeup and saving that image. They weren't using that to compare the people being pictured to any kind of database or to do any identification. And outside of the cosmetics context, CVS recently prevailed in getting a BIPA claim dismissed. And in this case, it involved a passport photo system. So at CVS stores, a CVS employee would take a picture of a customer with a digital camera, upload it into a Kodak system. The Kodak system would scan the picture and see, does this image comply with the federal passport requirements? Is the person positioned correctly? Is it the right size? And the court found that even if, that scan of a digital picture was collecting biometric information, it was not enough to allege that CVS was using that picture for identification or comparing the person picture to any kind of database. So let's go to the next slide, please. So for contrast, there are cases where courts are denying motions to dismiss where the plaintiff does allege that there is some type of comparison or identification going on. The first case we've given as an example was a case involving a company that took plasma donations. So those plaintiffs allege that they scanned their fingerprint at a kiosk each time they went to sell plasma, and the defendant was using that fingerprint to compare that information to a database. Essentially, they were looking as, has this person been here before? And that's an identification purpose, so it was enough to survive a motion to dismiss. And in another case with some interesting technology, plaintiffs were truck drivers who alleged that there was facial recognition technology in trucks, and that technology would scan their faces and look for driver fatigue or driver distraction, and to basically regulate the driver's behavior and see if they were performing adequately. And because the image collected was being compared to existing images of the driver, that was sufficient for identification purposes and enough to overcome a motion to dismiss. So we're seeing these BIPA claims, at least for Trion Technology, really turn on whether there are allegations that the defendant can use the images collected for any type of identification purpose. And if they can, are they actually using it for any identification purpose?
Okay, great. Thank you so much. So now we would like to turn to the world of data security incidents. So data breaches involve various types of unauthorized access to data, other unauthorized disclosure or unauthorized processing of data. Sometimes it's the typical hacker breaking into a network, but more often these days it's occurring via phishing and social engineering and all kinds of other different approaches, some of which involve AI. So Dustin, can you give us an overview of some of the trends you've seen in some of the more recent significant data breaches?
Hi, Deb. Yes, of course. I think you kind of hit the nail on the head. We have really a lot of different ways that attackers are really causing some really major data breaches. In terms of trends, we really are seeing the continuation of a trend through 2023, where data breaches continue to be more and more expensive year on year, and we're also seeing a trend of more and more different kinds of businesses being the victims of data breaches and security incidents. And so let me just talk about some of the key incidents that came out of 2023. And I just, before I want to dive into some of the details of these breaches, I just want to say, we don't, because these happened just in 2023, we don't necessarily know all the details about these data breaches yet. I think some more details will emerge in the months to come. But based on what we know now, I think some of the key trends really are that just as you said, Deb, social engineering attacks really are becoming more common and more sophisticated and more devastating for their targets. We're seeing a real increase in data breaches that are the result of software vulnerabilities. And one of the other things I think is just a really interesting trend is we're seeing a lot more government entities or public entities being targets of attackers that want to perpetrate these data breaches or other security incidents. So for instance, in the social engineering category, MailChimp, which is a company that sends mass emails on behalf of its clients, suffered a breach of all its records related to 133 business clients. That breach was a result of a social engineering attack where an attacker obtained a variety of employees' usernames and passwords and then used them to access an internal account management tool and all the data about the business clients that was available within that tool. And this was actually the data. This was of great concern to the affected customers and to Mailchimp, because the data that was taken could actually be used for more social engineering attacks on Mailchimp's customers. And so that was one of the chief concerns coming out of that incident. Now, Activision had a somewhat similar incident as well. Activision is a maker of computer and video games. They suffered an SMS phishing attack, or in other words, a social engineering attack perpetrated by SMS text messaging on an HR department employee. And even though it was just a single employee, that was an HR department employee that had access to a variety of human resources data. And the investigation of the incident revealed that the compromise actually began in early December 2022, but unfortunately, Activision wasn't able to detect it until February of 2023. As a result, the attacker that compromised the HR department employee obtained employees' names, email addresses, compensation information, and the like. Activision actually was, and this goes back to some observations I'll have at the end, but they didn't actually disclose the breach immediately. They were initially persuaded that there was no data stolen during this incident, but a research group that studies cybersecurity attacks found data stolen from Activision later, and that because of that finding, there really was some questions raised about whether Activision timely notified the people whose data was potentially compromised. Now, in the software vulnerability category, and which I think is actually a really fascinating category, because these these kinds of incidents, because software just isn't perfect, they can happen all the time into just really any kind of company. Because, and as we'll see here, some of these involve software that companies make for themselves, but others involve software that companies simply use. So, for instance, in the Chat GPT incident, the Chat GPT had simply utilized an open source code library, which is a very common practice, that had a vulnerability that allowed an attacker to exploit the vulnerability and obtain unauthorized access to records associated with about 1% of ChatGPT's customers. And of course, the key takeaway here is, for ChatGPT and others, even if you're using open source code, even well-regarded open source code, you still have to do your security testing to make sure that code is secure when you incorporate it into your product. T-Mobile's incident actually did involve the company's their mobile app that was customer facing, and it simply contained an error. And when customers logged into the app before the error was corrected, it exposed other customers' payment data to customers that were not that customer. So it wasn't, and it hasn't actually become clear how many T-Mobile customers were aware, and it appears from the initial investigations that there actually may be some difficulty determining which T-Mobile customers ultimately were affected. But again, it just really points back to the importance of careful software testing. I think the most serious of these three incidents is the MoveIt incident, which is a incident that affected a company that provides a tool for storing and sharing files and other data. And this company this was their own software, and they had a 0-day vulnerability that within their software that became public within the community of folks that do cybersecurity attacks. And multiple attackers actually exploited the vulnerability to compromise data associated with more than 1,000 of MoveIt's customers and more than 60 million individuals. And that data included financial services customers, military and government customers, healthcare sector customers, and the costs related to this incident have exceeded 10 billion so far, and likely will exceed 50 million before all is said and done. Just a very, very expensive incident. This third category I wanted to highlight really are compromises of government organizations. And yeah, I think this is an interesting trend as well, because I think not too many years ago, there was a thought like, oh, like banks and are like great targets for hackers because they've got credit card information or financial account information. But like, like some of our clients and some businesses out there would perhaps think to themselves, but we don't have data like that, so we would never be a target. I mean, I think some of these targets or excuse me, some of these attacks are just perpetrated indiscriminately by attackers who are just interested in seeing what data they can get and what use they can make of it. So the three major incidents we had here involved, well, the first involved the Indonesian Immigration Directorate. This was an apparent hacking attack. And the directorate has been very tight-lipped about what has actually happened. We do know that the passport data of more than 35 million people was compromised, and it was later made available for sale on the dark web for $10,000. So a fact I'll come back to here in a moment. But the next incident was the the UK Electoral Commission, and they were actually the victim of just a malicious code vulnerability, and they too have not been able to determine the exact number of people that are affected. But the UK Electoral Commission, just as it kind of sounds like, so they have the names of voters and addresses of all voters in the UK. That's about 45 million individuals each year. The Idaho National Lab is actually a U.S. Department of Energy lab, and they were compromised in an interesting way. They were compromised by a hacking group, but the actual compromise involved an HR database that was managed by a vendor that was outside the lab itself. Nevertheless, the database still included data, a variety of data on lab employees and former employees. And these are employees who are nuclear energy researchers, national security researchers, and other individuals who are involved in very confidential work and research. And of course, the concern here is that data could be used to compromise those people, to blackmail those people, to make those secrets less safe. So, even though government or agencies haven't historically perhaps been as high profile or targets, as I think it's perfectly clear that they are going to continue to be targets going forward. I also wanted to just briefly, before I moved on from this discussion of data breaches, mention 23andMe. It doesn't fall into either of any of these other categories, but I think it's just notable because 23andMe, of course, is a site that uses genetic information to sort of allow individuals to learn this information about their proclivity for developing diseases and to learn information about their ancestry. They had they were the victims of what was called a credential stuffing attack, meaning that an attacker used previously compromised usernames and passwords and tried them as usernames and passwords at 23andMe, and were indeed able to compromise about 4 million records on the service just by using those passwords. So the important safety tip for us all as users is don't use the same username and password on more than one website if you could possibly avoid it. But nevertheless, the what's so interesting about this one is that the data that was compromised included significant data on users of Ashkenazi Jewish descent and Chinese descent. And it really reveals that databases like this, when they're compromised, really enable the potential exploitation of certain classes of people based on the characteristics that are made known by those databases. So if we can move to the next slide, I think the sort of some of the key takeaways here about what we're seeing this year is that several of these data breach victims were sort of initially denied that there was a compromise, or that they may have acknowledged a security incident but denied that the data was compromised. And one of the things I think that really indicates as a vulnerability or a weakness in organizations and incident response teams, that they really don't have enough information about how to determine whether data was compromised. And usually that's done in two ways. One by looking at the systems that the companies or businesses have that keep records about data that's being transmitted in and out of the networks, in and out of systems, but also by there's specialized expertise of people who can look on the internet and find these data sets that are made available as a result of these data breaches for sale or for other exploitation. And although I did not really dive into the healthcare industry specifically in this discussion, I will say that the healthcare industry continues to be the leading industry sector for data breach costs, and those data breach costs are just like they are in every industry, just going up from year to year.
Thank you. Let's move to the next slide. And so Dustin, as Austin mentioned earlier, the FTC has sort of become the de facto federal enforcer of data privacy, data security, deeming that certain poor security practices are unfair or even deceptive if a company makes security promises and they don't keep them. Can you just give us a quick overview of some of the FTC enforcement in this area? Quickly, thanks.
Yeah, of course. So I think the key really is that although anyone can have a data breach or a security incident, the FTC really brings its enforcement powers to bear on companies that are sort of willful or reckless in terms of their security, or deceptive and make representations about their security that just aren't correct. And in the slide here, you can see some of the companies that have been targeted this year. But really, the common threads here are misrepresentation, that they have security when they don't. Many of these companies were putting putting data on internet cloud systems that had actually no access control or very little access control, no encryption or very weak encryption, and yet were making representations to their customers that they had strong security. One of the other things that I think the FTC is really taking advantage of are sort of egregious violations. So in the case of Ring here, which is mentioned toward the bottom, the FTC had actually alleged that the company had illegally surveilled customers in the private spaces of their homes, and failed to take reasonable steps to prevent people from getting access to those videos. So the FTC required them to engage in a fairly robust remedial program that includes independent outside assessments. In many cases, the FTC is assessing significant fines and significant requirements for outside assessments. And in one case, we had a company whose CEO was actually criticized for not maintaining an adequate security program, and was required to not only have an adequate security program going forward at that company, but at every other company he leads from then on out. So we're definitely seeing the FTC focus on the worst of the worst in terms of security incidents.
Well, thank you so much. So what are some key takeaways that companies should be learning from these enforcement actions, Dustin? Next slide, please.
Yeah, so key takeaways really: security governance matters. Like having a written information security program that really brings in key stakeholders, the people that are actually involved with information security, key executives, really facilitates understanding of security throughout the organization, facilitates making sure that budget dollars get spent to actually address the worst or more significant cybersecurity issues, fosters accountability, and really drives cybersecurity into the business. I think one of the other key takeaways is that most of these security incidents are preventable, and following any of the major cybersecurity frameworks, whether that's NIST or ISO or any of the other, or CIS controls, if you follow them carefully, they really will produce a solid and defensible program that has a good chance of fending off some of these security incidents. Obviously, don't ignore or cover up your security issues. Don't think you're not a target just because you're a public entity or not the kind of entity that you think is going to be a target. And perhaps most importantly, the social engineering attacks, because of artificial intelligence's increasing complexity and sophistication, are just going to get worse. They're going to get more deceptive and just easier to fall for. So one of my key recommendations is really don't rely exclusively on individuals' judgment. I mean, we should still be doing cybersecurity awareness training, but organizations really need to turn to defense in depth, having more than one defense to these kinds of attacks. So I think those really are the key takeaways from the security incidents this year and in years prior.
Thanks. And then I know we're at time, but let's just go to the next slide quickly, just to note that the SEC recently introduced a new rule relating to security incident response and reporting for public companies. This just went into effect in December. So we assume most of our public company clients are aware of this, but just in case you're not, this is, a critical new disclosure obligation. So, be sure you're aware of this. Please reach out to your Dorsey attorneys if you're not aware of it. If you're not a Dorsey client and you have questions, feel free to reach out to any of us who, in the US who have presented today, not necessarily our international colleagues. And there are some, short time frames here. So, really need to prepare with your incident response plans and your whole executive team. All right. I think we need to wrap it up. Thank you. Do we have time to go through these? Lori? I'm not sure if we do.
I think you can take like another minute and then we'll need to.
Okay. All right, great. Okay, Jennifer, do you want to just give us some quick planning for prevention with regard to preventing cybersecurity incidents, please?
Sure. I think that the most important thing is that most cyber breaches are caused by human error, usually through email or some type of phishing or compromised hardware. And so it's very important for employee training to understand, for your employees to understand what it is their obligations are. The other part that's really very important right now is your master services agreements and how your vendors are protecting your data. That seems to be a very big vulnerable spot right now. So you need to make sure that your master services agreements, et cetera, are up to date so that your vendors understand the level and the type of security that you require with your data. Essentially, it is about prevention. It's about tabletops. It's about looking forward into what may happen. But that's certainly something that we can advise you on. I don't want to take any more time for today, but I'm more than happy to answer questions later.
Can we just wrap up here? I think we're going to wrap up. Thank you so much to our panel, our third panel, and all of our panels for all the great information that you shared today. And thanks to all of our attendees for coming and thinking about all these important issues. You'll see we have speaker biographies at the end of the materials if you want to learn more about any of the people who spoke. And remember to return your sign-in sheet to attendance@dorsey.com so you can get CLE credit. And we're happy to be in touch with anybody who has questions after the fact. So thanks so much again, and have a good rest of your day.